Good afternoon, everybody.
Good afternoon, Mum.
Good afternoon. Could everyone who's taking part again put their cameras on, please? Marvellous, thank you. Carmel, can I just check whether we have anybody new observing or whether it's just the people who've been observing throughout?
It's the same people as this morning.
Okay, thank you.
There's no one different.
Okay, thank you. So I don't need to do introductions again or anything like that. Thank you. Well, welcome to the afternoon session of the hearings for the second day. We are going to move on now to discussing the wider statement of common ground, triggers and timing of submission of a replacement local plan. That's covered in questions 6, 6A and 6B. We will also cover question and 6C. We'll also cover question 7 as well as to any other plans which have the potential to impact on matters being discussed. It would be very helpful for me to turn first to the statement of common ground on the comparison of triggers used in recent local plans in Leicestershire. It has been agreed between North West Leicestershire and some of the other participants. Has everybody else seen a copy of it who hasn't been involved in the drawing up of the agreement? Okay, thank you. I'll come to Mr. Nelson, I think, first to explain the reason for submitting the statement of common ground and what you hoped would happen as a result of it. I think it would be useful to discuss that, or at least give me a summary anyway.
Yes, thank you, Madam. The purpose behind it was when I was reading the various representations that made comments about other local plans in Leicestershire which had triggers in. I must admit I was getting confused, and obviously I know Leicestershire probably better than most people. So it just seemed to make sense to try and pull something together to sort of summarise as easily as possible what those different policies in those different local plans were saying, try to pick out some of the common factors or not common factors, just as a means really to aid discussion today. That was the simple purpose behind it.
You do it.
Okay.
Sorry, carry on.
No, carry on. No, if you hadn't finished, I just heard somebody in the background, so I wasn't sure.
No, likewise. Yeah, so I mean, obviously, what we've put forward in terms of the change to policy 1 does include one trigger, which is the wider statement of common ground. If you look at some of the other local plans in Leicestershire, they do include other triggers, but as noted in the statement of common ground, those triggers are always about starting a review. Obviously, that is a process which we know from this morning that we are already fully engaged in anyway. Our trigger is a trigger after which the plan has to be submitted.
Okay. And some, I having looked at this, some also have triggers, I suppose, following that as well, don't they? I just want to clear up a basic question, I suppose. A couple of the policies mention a statement of common ground, and a couple mention memorandum of understanding, and I think one mentions both. So it would just be helpful to understand from your perspective, if you're able to, Mr. Nelson, what the difference is, if there is a difference.
My understanding is that there isn't a difference. I think it's just a case of terminology changes through time. So if we go back to when the Hedna was being produced, and even before that, actually, memorandum of understandings were agreed by the local authorities. Obviously, now the government has sort of formalised some of the duty to cooperate arrangements a little bit more, and refers to statements of common ground. So my view would be that they are one and the same thing. I noticed Mr. Thornhill is present today, and he was at Harbour at the time that they had their examination. So I don't know whether he would agree with that view, because I think the Harbour plan does talk about both from memory.
Yes, yeah, I would, and then I'll come to you, Mr. Bamford.
Yeah, so yeah, Ian's summary there is fair. I think the reason why it refers to both at Harbour was, I think when the policy was originally drafted, it probably referred to Memorandum of Understanding. Then the new MPPF was published, and although it was tested against the old MPPF, it was just to update the terminology to cover all bases, basically. So it's a terminology point of view that the general substance of them was intended to be the same.
Okay, thank you. Mr. Bamford, would you like to say something? And I know you're one of the parties that signed the agreement, aren't you?
We are, Mum, yes. It's more just to concur with what both Mr. Nelson and Mr. Thornhill said. I've had the pleasure to be at all of those local plan examinations. All took kind of place in different points in time, and it is simply where we were at that particular point in time, which terminology was used in the particular trigger mechanism.
So if you were looking at one of these particular policies, are any of you suggesting that one is more relevant than the other, perhaps to North West Leicestershire's, or is there anything contained within parts of these policies that you think would be relevant? Just to help out. Otherwise, I suppose there's still a kind of pick and mix choice, isn't there?
I think for our purposes, Mum, it is a pick and mix exercise. Obviously, I think North West Leicestershire were the first through this particular process, and that's probably led partly to the wording that was included in that policy not being quite appropriate for now, certainly. I think as we went through those processes, we tweaked that wording, and I think we're now moved on considerably from that point again, and I think it is a pick and mix process to get the best of those trigger policies into whatever the trigger policy is for North West Leicestershire. I think the concern from our point of view has always revolved around both time frame and some kind of backstop stroke fail safe should progress not or sufficient progress not be made. And I think that's the critical element of getting this trigger mechanism right for North West Leicestershire.
Okay, thank you. Did anybody else who wanted to comment? I will come back to you, Mr. Richards, in a minute. Anybody else who signed up to the statement of common ground for the triggers want to add anything? Mr. Fox?
Yes, thank you, Mark. We were involved in drafting and agreeing the statement as well. I was just going to mention, I think from our perspective, we think the statement of common ground approach, the trigger to that is absolutely fine. But I think if you look at, I think it's Oby and Wigston and also Harborough, they do have backstop dates built in. So they have an additional backstop date in addition to the memorandum or the statement of common ground. And I think both of those they both equate to 30 months when you add up the two triggers. So I think from our perspective, we'd welcome some form of backstop being built into the policy.
Okay.
I'll still make sorry, man. One other point as well is that having looked at the wording of the revised policy, the draft policy, it's referring to Leicester City's unmet needs specifically in the second element of the paragraph. Whereas if you look at Melton and Oby and Wigston, they're both referring to sort of general unmet needs across the HMA. And I think given what we discussed this morning, whereby there's a potential that Leicester may be able to meet its own needs under any new standard method, but there could be unmet needs elsewhere in the HMA. I think that's just something which should be allowed for in the policy rather than being definitive specific just to Leicester City. Thanks.
Okay. Yeah, thank you. I'll come back to Mr. Nelson on that point, but I will hear from the others. Sorry, just bear with me while I can't see everybody on the screen at the moment, so I'm just checking who's raised their hand. As Mr. Richards, I will come back to you. Miss Green.
Thank you, ma'am. Yes, we're also one of the parties who was involved in putting together this statement of common ground. I mean, we feel that it's sort of a factual statement, and I think that the table shows how this type of policy in the Leicestershire HMA area has sort of evolved over time as we've gone through numerous examinations of local plans. And I agree with Mr. Bamford that that the approach probably is a bit of a pick and mix. But what I felt that the statement of common ground and the table enabled us to do is almost to move the discussion along by sort of saying, well, if you had a final column, you know, what would you be putting into that final column with regards to each of the lines? So I felt that it was a useful document to have produced to help us to sort of move forward on what kind of triggers we think should be in there. We share the concern of most of the participants that we feel that as the policy is currently drafted, it is just too open-ended, and it might never come to a resolution. So we were also seeking to have some more, to try and put in a little bit more certainty, but equally with sufficient flexibility there, so that as Mr. Fox has mentioned, at the moment there is reference just to unmet needs from Leicester, but looking forward and building on the discussion that we were having this morning, it may be that in actual fact other unmet needs evolve if we move to the new standard methodology, etc. So we need to have some flexibility in there, as well as trying to create some more certainty as to timescales.
Thank you, that's helpful. It might be worth taking your idea of the final column into the discussion as we go along. But I will hear from Mr. Pendle and then Mr. Richards. Mr. Fox, have you finished? Your hand's still up, so that's okay, thanks. Mr. Pendle.
Thank you, Ma'am. I won't reiterate what the points that others have just made, but certainly would endorse those. It strikes me that each of the policies are very much of their time and use the terminology that's probably prevalent in the individual local plan examination cases. Something that strikes me is the difference between what a document is called and what it deals with, and to what extent it deals with it. So, for example, Memorandum of Understanding previously has dealt with the vehicle for potential agreement, officer member groups, not necessarily the extent or scope of evidential matters that might need to be dealt with. And of course, even that second part of that, the evidence around what we're trying to achieve here is a further step removed from actual policy, where we might actually ultimately end up in terms of what we're actually trying to achieve in terms of spatial planning. So what the document's called is one matter, but if it's dealing with process, policy or mechanism is another matter. And for me, one of the things that, as I said, the individual trigger policies are very much of their time, and I think we can all recognise that. And we recognise that Harborough's trigger policy talks about the Leicester City plan because that was writ large during that examination process, and indeed we are where we are now. And you heard me make comments about the existing trigger policy being a product of the North West Leicestershire Local Plan as it was then. So I think to try and sort of move us along, Ms. Green's mentioned this final column. I think if we can focus on what it is that we're trying to wrestle with rather than what the document may or may not be called, that would probably be helpful. You know, what is the explicit matter that results in the need for action to be taken? Because of course, you know, I made the comment this morning, joint statements, statements of common ground, MOUs, you know, they are what they are. It's what they actually say and what they do that really matters. The second point I just briefly make, perhaps save me from coming back on in a moment, would be the trigger as written in the adopted local plan effectively hit the alarm and set it at the point the inspector's report came out, gave that date for 3 months for the review will commence. Mr. Nelson's quite, you know, obviously correctly said we've already commenced our review. But in hitting the alarm or setting the alarm, it then sets the end date for that to have happened. So in other words, the alarm's set, it's running, and we know when it's going to go off. And within that period of time, the type of matters that I've just been talking about, rather than the actual name of the document or you know, directing us towards somebody else's stuff, it was the actual content that North West Leicestershire were under pressure to try and influence in order to keep some life in their plan, notwithstanding comments we'll have later on deeming clauses, no doubt. But it put the pressure on them to work with their partners to achieve that. What we've got now, of course, is, well, the clock has started on the local plan review, but potentially the alarm doesn't go off until such time as maybe or maybe not a statement of common ground is achieved, which maybe or may not deal with actual matters of numbers, spatial distribution, and responsibilities and roles for different local authorities. So, for example, if a statement of common ground is issued which simply deals with a new mechanism and doesn't pick up on any of those things I've just mentioned, then it's arguable that the timescales for submitting the plan or completing it no longer relevant. So for me, it's content and having, you know, with the best will in the world, and as you know, Mr. Nelson will know I've got a lot of sympathy with him because we've worked on local plans together before and had exactly this problem. The individual partners in the HMA need the pressure to work together, and it can't simply be left to a statement of common ground, which may or may not happen. And of course, the alarms only hit if it happens. You know, it has to be different to that.
Yeah, I mean that was the point of my second bullet point on the agenda, was to what extent actually can the wider statement of common ground and its contents be influenced by the partial review itself. You know, I'm not entirely convinced that it's for the partial review itself to set what the statement of common ground will be. I mean, obviously, it's a discussion that will be had, but equally, all the Leicestershire authorities aren't here at the moment, so they won't be party to this discussion. I think we'll come back to that, and certainly to this hypothetical final column at the moment that we might have for the triggers statement of common ground. Mr. Richards, you wanted to say something.
Yes, thank you, Madam. It seems to me that there are three issues that we're going to be grappling with during this afternoon. The first is, should there be a trigger for submitting the local plan? And at the moment, the council is proceeding on the basis that there should be, unless you tell us otherwise. But everybody's noted that we're already embarked on the substantive local plan review, so it's not a trigger requiring us to commence a review. We're talking about a trigger to submit the local plan for examination. The second question then is, if there should be a trigger, what should that trigger be? And it seems to me that there are only two possibilities. One is a fixed date, the 25th of December 2022, for example, or a date relating, unknown, but relating to the time of or after a future event. That's the sort of trigger being proposed by the council, and the future event is the agreement of a statement of common ground. Other people might say, no, it ought to be a different event. And if they think that, then we think that would be helpful if they identified the event they have in mind. And then lastly, which we'll come on to later, which we're not embarked on at the moment, the final question is, should there be any consequences spelt out in the policy in the event of a failure to meet the trigger? Should it be a deeming clause or some other consequence? Should there be any consequences spelt out? So it seems to me that those are the three things that we're wrestling with. And at the moment, it appears that everybody thinks there should be a trigger, but we're not all necessarily agreed on what that event should be. And then some people say there should be consequences and other people say there shouldn't, including the council, spelt out. But we'll come back to the consequences debate later. At the moment, we're focusing on the trigger. We think that the content, as Mr. Pendle correctly described it, is when everybody is agreed what the unmet need is and where it should be met. And the vehicle that we've identified for that is this statement of common ground. But if somebody thinks that it should be a different vehicle, then we're very willing to listen.
Okay, thank you. I mean, just coming on to that point, that's the first point, isn't it, that's made in this table in the comparisons about addressing unmet needs either in Leicester City or elsewhere. Mr. Nelson, what are your thoughts on that? I mean, obviously, Leicester City was referred to specifically because that was an issue at the time. Have things moved on in that respect, do you think?
Well, not in the sense that nobody else has declared an unmet need, but I do take Mr. Fox's point on board, and I think there would be some merits in a slight rewording of that part of the policy to make it clear it isn't just Leicester City, it could be any of the authorities within the housing market area, particularly within the context of government's proposals for the standard methodology, which who knows what that might mean for other authorities across Leicestershire. Some authorities who currently are able to meet their own need, they may not be able to, possibly. We don't know. So I think it would allow for that possibility as well.
Okay, thank you. Mr. Lees.
Thank you, Madam. Yeah, I'm just wondering to what extent the precise wording is material to the actual situation of the council undertaking a review, because again, I think what we're all trying to achieve is a mechanism whereby the council is going to undertake a comprehensive, the substantial review as swiftly as possible. So I think that's where we're all trying to get to anyway. I guess the question is, to what extent does any wording here change the statutory requirement for reviewing plans in any event, and obviously for those reviews to be completed no later than 5 years from the adoption of a plan as well. So I guess it's just understanding how quickly North West Leicestershire could in any event, having already started, as Mr. Richards says, the process of the substantial review, not formally. We haven't had a Reg 18 consultation yet for the comprehensive review. So it's just understanding how the wording here is going to relate to other provisions, which is the statutory provisions here, and anything that might come out in the white paper. Because I understand the predicament. This review is needed within 5 years of the November 17 adoption of the existing local plan. And in terms of the changing circumstance, that changing circumstance is this unmet need that needs to be established. So I'm just thinking, how quickly could that be done anyway, really? If we've got some comfort in terms of the timing of the statement of common ground, And if, as Mr. Fox says, you know, there is potentially a long stop date in there, that might give some comfort. But I was just thinking how critical is the wording here when, you know, they're going to have to get cracking on it anyway.
Yeah, Mr. Nelson, did you want to comment? Your hand's raised.
Yeah, it was just the comment from Mr. Lees about not been any Reg 18 consultation on the substantive review. Obviously, we did start the will become a substantive review process in February 18, as required by Policy S1. We ended up in this situation where we then had to sort of diverge between the substantive review and the partial review. But certainly the consultation we've undertaken so far will feed into or is part of the substantive review.
Okay, thank you. Mr. Richards?
Yes, just to make sure that we're not proceeding on under a misapprehension of the law. I share Mr. Lees's enthusiasm for getting on with it, but the requirement to conduct a review in the NPPF and in Regulation 10A is a requirement to conduct a review, not to complete review. So that the review there, PPG makes clear, is a review to decide whether your plan needs updating. So every 5 years, you have to decide whether the plan needs updating. This council's already done that and said, yes, it does. It needs a substantive review. So that 5-year period mentioned in the NPPF is for that process. It's not 5 years between adopting one plan and adopting the next, which is what we thought it would be when the idea was first floated. But in fact, the NPPF and the PPG and the regulations say something different.
Okay, thank you. Still got Mr. Nelson, Mr. Pendle's hands up. Did you want to say anything else again?
Yes, sorry, I just want to go back to what I said earlier on and probably just to sort of correct something, I suppose. In Policy S1, as it currently stands, it does actually refer to District Council will work with the other authorities to establish the scale and distribution of any additional provision that may be necessary in North West Leicestershire and elsewhere in the housing market area as a result of the inability of one or more authority to accommodate its own needs. So I'm sort of going back again to Mr. Fox's point. So it does recognise that there may be a need to accommodate unmet needs from elsewhere than Leicester, but then the final part of that policy does just refer to redistribution from Leicester City. So whether that part needs looking at, but just to be absolutely clear, the policy does do that anyway.
Yeah, I think it would be helpful for it to be consistent in that respect. So that would be something that would need to be looked at, just so it's clear what the aim of the policy is. Okay. Mr. Richards was referring to what the trigger should be. I think the majority of participants here seem to agree that the statement of common ground is the appropriate trigger. Is that correct? Or have I misread anybody's comments? So I think that's right. It's just whether there is an additional backstop, I think, or other dates referred to. So just coming on to the statement of common ground then, yeah, I mean, there was a bit of a discussion about what the statement of common ground should include. I'm not entirely sure whether that is something that this particular examination can influence to any great extent. I would suggest that's a matter for the authorities. I do know, I think Mr. Lees, you suggested some things that the statement of common ground could include, like commitments from each authority to meet its own housing needs, cumulative figures. Is that correct? Is that what you were suggesting that?
Yeah, it was just, I guess I was looking for sort of really for the purposes of this examination, potentially having, because we've got the statement of common ground, which is in support of this examination, November 2019, and then we've got this emerging statement of common ground between the authorities in terms of the redistribution. And clearly where I was really getting at for the purposes of, for this examination, having a meaningful, an effective statement of common ground was to have more detail as part of that statement of common ground for this process. Clearly, we can't fill it in and ascribe the numbers. Obviously, there is a significant process to go through for that. But it was just having a bit more detail about what that statement of common ground might be, and if that is an iteration. And if we're moving on away from a duty to cooperate point, obviously a statement of common ground is a living document. You know, the extent to which you know, that is something that could move on, but I appreciate that, you know, trying to get all the authorities to sign it, if it's just for the purposes of this examination, whilst the main focus is on the meaningful statement of common ground, if I can put it like that, I understand the problems with that. So I think it's a bit much to ask for that to happen in any reasonable time frame for the purposes of this examination. But yeah, some comfort, however it's presented as part of this examination, in terms of what that future statement of common ground will contain and time period within which it is likely what they're aiming towards. I appreciate there's politics, there's a huge amount of politics involved in agreeing to a redistribution of housing need, as well as all the sustainability appraisal work. So I appreciate it's a lot to be gone through, but if we can be given some comfort as to what it's going to include and timescales without it being a signed statement of common ground, that would be, I think, very helpful to give the participants to this examination and yourself, Madam, some comfort about putting in potentially a long stop back date as part of the wording for this policy. Okay,
thank you. I'll come. Mr. Pendle, you've got your hand up still. Is that a new comment you want to make, or is that?
It is, Ma'am. I mean, I hovered over reacting to your question about whether or not everyone was agreed that it would be a statement of common ground, and I don't want to be the Jonah here who says no. But my point about the content of it, you know, is writ large in my mind, and certainly, you know, Mr. Lees has just run through very deftly some of the reasons, you know, that I certainly agree with for that, and I suppose it's trying to tread a fine line between what we may ordinarily expect of a local plan examination, obviously in this case Northwest Leicestershire, and Ian's sanity, versus para 11B of the NPPF, and how we reconcile unmet needs from neighbouring authorities when we're testing a local plan soundness. And clearly, you know, Inspector Sims went through that went on that journey in very similar circumstances and arrived at a trigger, and there was a backstop. You know, if I cut the story short, you know, I agree, Mr. Lees has very, you know, carefully just said the comfort would come from the backstop. That's where Inspector Sims arrived at, and I think probably I would find support from others on the screen in the room if I said, if it was left to a statement of common ground which may or may not take place, to work out what should happen with unmet need. You know, we already know there is unmet need, and for that to then set the clock ticking, that would not be enough to encourage the partners to work together. Okay,
we'll come back onto what the backstop might be just shortly, but Mr. Nelson, you had your hand up, and then I'd like to come to Mr. Thornhill, I think, just to talk about the process that we're going through in terms of the statement of common ground.
It may well be that I accidentally covered some of that, if I do, apologies. Yeah, it was just to make the point that paragraph 2.5 of the joint position statement that was published on Monday, it's very clear there about what the unmet need is for both housing and employment, and also it does give some idea of what the timetable is for getting that all agreed. So the sort of information that people have said is needed is now there in that joint position statement.
Thank you. And then in that case, Mr. Thornhill, does the joint position statement, does that provide the basis for the statement of common ground? Will it flow from it? Will it say similar things, or will it provide more detail? Have you got any idea of what the contents of the statement of common ground will be?
Yeah, the content will be quite simple. It's just getting the evidence together to support that. In my mind, it will be a simple table which will set out the housing targets for each of the authorities, basically, with the unmet need redistributed as part of that. We've discussed about flexibility in that, so there's probably a discussion that we need to have internally amongst the authorities about how we can build in some flexibility to that if Leicester's unmet need changes within a reasonable range. You know, could we agree a range instead of a specific number? We're not at the point where we've discussed that in any detail and know the answer to that. But obviously the duty to cooperate is ongoing anyway, so there's only a certain degree of flexibility you can build in, and if things change dramatically, then we'll obviously have to do a new statement of common ground that responds to that. So in my mind, this is an ongoing, never-ending process, really. We're at the start of it now, or towards the start of it, given the situation that we're in, with the emerging situation as we've discussed. But I think that you mentioned the backstop there. I think we just need to be careful, if Marmia minded to go down that route, that we don't assume that Leicester will have an unmet need, because what I don't want to do is start the clock like we've got with the situation at the moment, where it was assumed Leicester would have an unmet need and it will be dealt with in a specific time. We've discussed the emerging housing figures, which the government's consulting on at the moment, not as part of the white paper, the changes to the current planning system consultation and the changes to the standard method there. If the government was to adopt that in 2-3 months' time, there may not be an unmet need to deal with. So if we've got a trigger that's linked specifically to Leicester's unmet need or the timing of Leicester's plan, then North West Leicestershire might find themselves in a similar situation where they've got a trigger that set the clock running, and they've got to submit a plan for an event that hasn't actually happened. So I'm not saying that a backstop isn't possible. We just need to be careful we don't repeat what happened last time, basically, with where we're prejudging what's going to happen when we don't actually know. If you see what I mean, it needs to be a more general backstop, I would suggest, if you're minded to go down that route.
Okay, and the wider statement of common ground, that is intended at the moment just to deal with Leicester, assuming that there is an unmet need for Leicester. It's just going to deal with that and not any potential from any other authorities. So there might need to be other mechanisms to deal with that.
Yeah, we've got a very complex situation here, because we've got an authority, particularly Charnwood, looking to submit a plan relatively early in 2021. So there are transitional arrangements at the moment in the current consultation to change the standard method, where if the government bring that standard method in, there's then 3 months to submit a plan. And so Charnwood and possibly Leicester could quite easily be submitting a plan in those transitional arrangements. So even if the new standard method's brought in the next month or two, there's a strong possibility that 1 or possibly 2 plans will be submitted under those transitional arrangements based on the current standard method. In that scenario, we end up in a sort of a parallel universe where we have an unmet need for Leicester that only exists for Charnwood's local plan and nobody else. So you can see how it gets very, very complicated very quickly, depending on what the government do. So there's a huge push to get this statement of common ground over the line, come what may, because it's likely that at least one authority will be submitting a local plan based on these need figures that we know about at the moment and an unmet need in Leicester. But other authorities and the North West Leicestershire substantive review may well go through in a different situation. Their plan's likely to go to 2039, not 2036. And obviously we're dealing with a situation here up to 2036. Their current plan that we're involved with here is to 2031, and Leicester's unmet need to 2031 is only around 1,800 homes, according to their trajectory published on Monday. So there's a whole set of complex scenarios that can emerge. So I just think it's important, whatever we do with the trigger, and if there is a backstop, that it's linked to events. I mean, in my mind, the MPPF provides the solution anyway. In terms of it requires authorities to carry out a review and to establish whether their plan's out of date effectively and whether they need to update the plan. So I think the mechanisms in the MPPF, in my mind, as it is, whether we want to go further in terms of specific wording in the plan, is obviously not a discussion for me, but that's a matter for yourself.
Can I just get a couple of participants have mentioned Charnwood. Charnwood, as far as I understand it, aren't intending to meet any other need except their own. Is that correct at this stage?
At this stage, their plan hasn't been based on meeting unmet need, but obviously that's yet to be decided through this process. So it's not, the process hasn't been finished or completed, but I suppose they were in a similar situation to most authorities that have adopted plans over the last few years, in that they've been progressing a plan, but we haven't had a quantified unmet need for Leicester. That's obviously recently come to the fore, and the consultation's happening at the moment.
Okay, thank you. I've got a number of people with their hands up, so I'll come to Mr. Nelson first, and then Mr. Richards, and then others.
Yeah, it's just to pick up on that point about Charnwood. I don't think you'll be too surprised to hear that we did pick up what they'd said in their local plan and expressed our surprise, shall we say, that they were making what seemed to be a unilateral decision. But my understanding is it wasn't intended to be them to be saying that they are not going to take any unmet need from Leicester. It's just that at that point in time, they weren't required to, because obviously, as we've said, that the level of unmet need and the discussions about how that was redistributed hadn't been undertaken.
Okay, so that might evolve then, depending on the signing of the statement of common ground or not, or agreement. Mr. Richards.
Yes, madam. Can I just thought it might be helpful, because I'm not clear what is meant by backstop when people on the screen are talking about that there needs to be a backstop. At the moment, there is the date of the statement of common ground, and then there is a requirement to submit within 18 months of that. Beyond that, is there any need for a further trigger, or is the reference to a backstop what I called the consequences? I can understand that people on the screen are keen that the substantive review should progress, and if the council doesn't progress it sufficiently swiftly or with sufficient energy, then quite obviously what they want to achieve is the engagement of the tilted balance. That's the practical outcome. Everybody is quite happy for a plan-led system to work, but what they want is some comfort that if it doesn't work to their satisfaction, then the tilted balance will be engaged. But Why do you need anything more than that which already exists in paragraph 11D of the framework?
Yeah, I mean, I have to say, my sense of what people were saying when they're talking about the backstop was a number of people have referred again to the plan being out of date.
Yeah, I mean, if you have a deeming out of date provision, sorry, I was talking over you. If you have a deeming out of date provision, that takes us back to where we are now. Otherwise, paragraph 11D in the framework is perfectly clear. If, as a matter of planning judgment, a decision taker, be it the council's committee or an inspector on a section 78 appeal, decides that the council has not been moving along sufficiently swiftly, that decision taker can say, as a matter of planning judgment, I think this plan's out of date. Sufficient progress with its replacement is not being made, and therefore I'm going to apply the tilted balance. And no doubt that might be the subject of arguments against a known factual background in a future section 78 appeal or planning committee meeting. But for you to try and predict that into the future is fraught with difficulty in a plan making context, in my respectful submission.
Thank you. Yeah, that's what I was going to say anyway. We were going to be back in the same position that we are now. I think that's my sense anyway, with some of the suggestions about the plan being out of date. Mrs. French, sorry, you've been waiting patiently for a while. What would you like to say?
Hi, thank you, Madam. A couple of points really. I think I'm a simple planner and I like to see things very simply. Ultimately, I think what we're trying to achieve is that the required number of houses within the housing market area are delivered in the most sustainable locations. Turning to Mr. Richardson's point, I think the backstop will provide certainty so that everyone can understand what are the consequences if this happens or if that happens. And I think the way that these plans have evolved, the statement of common ground is a good point of reference, but it might change, it might be something else, and having another reference would allow for that change to happen. So it wouldn't necessarily have to be the statement of common ground, it could be, you know, the sustainability appraisal or something else that comes forward and provides the indication of where the houses are needed and when they need to be provided.
So when you're referring to a backstop and when others are, what is it that is in your mind when you're saying what is a backstop for you? What does that mean?
For me, what I would like and what I'd like to be able to tell my clients is when that plan or when those numbers are going to come out. Basically, that's what I want to know. I think that it will provide some form of clarity for the whole of the Leicestershire area, and I think it will provide a focus of when that could happen.
Okay, and at the moment, that seems to me that the statement of common ground is currently the only vehicle for the numbers and where they'll be distributed if that is the case.
I would agree. At the moment, I think that is the document that we're all looking at or looking for, but that might not be the case in the future.
Okay, thank you. Mr. Lees.
Thank you, Madam. There's a couple of people have spoken since I put my hand up, so there's a couple of perhaps things I'd like to respond to in one go. I think firstly from Mr. Richards' point of view, we haven't got a date for the statement of common ground. So the whole timing process of undertaking a review is a statement of common ground, and there's no date for the signing of that or the agreement of that. It's just that it will be agreed. And obviously it's pertinent, your next question, I think 6B is what's the implications if the statement of common ground isn't agreed. Mr. Nelson alluded to a few times about the plan-led system and the need for a plan-led system. You know, we need to be planning for the housing requirements of the housing market area as a whole. So each plan needs to set a housing requirement figure that takes into account dealing with the housing needs of the HMA as a whole. That's what we all want to see, and therefore, you know, any issue in terms of looking at the relevance of policies in plans and so forth is, it's all well and good if you're looking to make an appeal, but the bottom line is we want up-to-date plans that meet the housing need. So it's all about getting plans in place for me that's meeting the housing need. Which brings me back to this statement of common ground, and I was interested to hear Mr. Thornhill talking about that, and Mr. Nelson. I was comforted by what Mr. Nelson said in an earlier session about it will have some flexibility in there in terms of potentially looking at a range, and that the sustainability appraisal will test a range of figures, because on the one hand, whilst we're keen to get this agreed, and so each authority has a figure to work with, the nervousness is that obviously things always change, and how quickly is that figure then going to become out of date. So what I'd be interested through yourself, Madam, is from Mr. Thornhill is to understand the potential for that statement of common ground to deal with potential different scenarios. Whilst we've got a figure, which is the base figure we can work on from Leicester City now, just over 7,000 houses, if we have a range either side of that figure, which is agreed within the statement of common ground, you know, that may, you know, lead to only us having one statement of common ground, and we haven't then to go back and revisit that in 6 months' time because it's out of date. So it's just understanding the ability for that statement of common ground to include some flexibility to take account of potential future changes now as part of that one statement of common ground, because trying to go and agree this politically and through a sustainability appraisal is very difficult. Again, I don't envy Mr. Thornhill's task in terms of trying to do that as well. So if you can build that in and you can nail it with each of the authorities once, you know, if it's this, we'll accept this, you know, if it's a percentage or something, then clearly that's going to help everybody moving forward, and therefore each plan process hasn't then got to be halted or wait pending the signing of a new statement of common ground. Everybody can crack on effectively, which will be a good place to be for everybody, I think, across Leicestershire.
Okay, thank you. I'll come back to Mr. Thornhill. I have a question for him in a moment. Miss Green, you wanted to say something.
Yes, it was answering the question of why are we talking about the need for a long stop date. And I think that the origin of that is that if you read the policy, it says that the submission of a replacement local plan will take place within 18 months of the date at which the statement of common ground is agreed by all the authorities. And I think that what's concerned participants is that, but what happens if it's never agreed? If the statement of common ground is never agreed, then there isn't a date from which you measure 18 months on from to submission. And that has been a concern because, as we've said, we've been in this situation for a number of years, and we keep being told that, you know, the statement of common ground is being prepared and it will be signed, and we've never reached a point of actually seeing that, and therefore, you know, our faith is dwindling that it will get agreed, and if it doesn't get agreed, then there is no time frame, and that is what has concerned parties around the table, and that is why we have put forward the commentary that we feel that there needs to be another date, a long stop date by which submission of the substantive review shouldn't go. And also why we've brought up conversations about the fact that there should be some consequence. So that's where the origin of the discussion about long stop date derives from, is the fact that And I think I may have jumped ahead on the agenda, because I think there is a question about what does agree mean, and does agree mean signed, etc. But that's the origin really of why we have been pushing for an alternate date in case it isn't agreed.
And what would your alternate date be?
Well, I mean, we had the same discussion at the Harborough examination, and as people have said this afternoon, a lot of these clauses are of their time, of what was happening at that point. And at that point it was, as has been said, it was all very focused on unmet need in Leicester City. As we've said, that things are evolving, that may no longer be the case looking forward. But I think possibly as a long stop date, I think Mr. Richards, perhaps, I don't know if it was tongue in cheek, but he did suggest, what was it, the 22nd of December 2022?
Yeah, 22nd of December.
Now, you may say, well, that was a tongue in cheek comment, but I think has also been clarified. That would be around about the date that the council should have been looking to see whether they needed to do a review in the sense of their plan being updated. But as Mr. Richards has said, that doesn't mean that they would at that point have submitted a replacement plan for examination. So perhaps putting that in as a date is actually saying, well, we will have submitted a replacement plan, not just as set out in the NPPF. We will be thinking about whether we need to be doing a review of our plan.
Okay, thank you. I mean, that does go further than the other plans. A lot of the other plans are tied to have certain triggers, don't they? And again, you know, just looking at Harborough's, it was 12 months of Leicester City's Reg 19 plan being submitted, or within 6 months of the Statement of Common Ground, I suppose, whichever is earlier. Or monitoring. So there are a number of triggers there. I'm not sure whether a specific date would be helpful, but Mr. Nelson, can you just comment on that?
Yes, thank you. Yeah, I was just going to come back and say, yeah, you're quite right in terms of the Harborough plan, but of course that is about when the review is to commence. We are already in that review. The substantive review, you know, is ongoing. We have started that process. And in effect, it was policy S1 that required us to do that anyway. And that's always been the problem I've had, is when people have been talking about additional sort of triggers. And again, I might be jumping ahead slightly on the agenda, but I think a number of people have made references to if there'd been a significant change as a result of, say, changes to the standard method. But again, that's about triggering a review. That is a review process that we've already started. What we're talking of here is something different. It is about an end date.
Yeah, just looking further down the tables, Oadby and Harborough both have their have a period within which the review should be submitted for examination. For Oadby, it's 24 months, and Harborough 30 months. So is that's similar to your 18 months, isn't it, from the Statement of Common Ground?
Yes, and the reason why we put in 18 months was is that we recognise that the process had already started. So certainly, you know, 30 months, such as was agreed at Harborough, I would have to concede be unreasonable. But whereas 18 months seem more reasonable.
Okay, thank you. We'll come back on that. Mr. Pendle, though, did you want to say something? Yeah,
thank you, Ma'am. That's really helpful from Mr. Nelson, I think. And I sort of see on the one hand a comment that, you know, local plan can be out of date by virtue of the NPPF review every 5 years. Ms. Green's cleverly made the point, consider whether to review it every 5 years. You know, that's probably been noted by all of us. But on the one hand, there's that the potential for that to happen. In other words, no need for a trigger policy at all, actually, because you could stand back and say the NPPF takes care of it. On the other hand, Mr. Thornhill has suggested that there's a whole host of different things that could happen here and play out. And certainly the Melton and Harborough policies include a number of clauses for a variety of different things that could take place that could lead them to need to do a review. And so on the other hand, you go from the MPPF taking care of it to actually trying to cover all your bases potentially within a trigger policy. And of course, that's very difficult. That's very difficult to achieve, because where do you stop? I'm minded, I mentioned Mr. Nelson's suggestions, very helpful. 30 months would be unreasonable. 18 months is more akin or more aligned to Harborough and Melton. And far be it from me to say what the answer is, and I know you might ask me, Mom, and I would struggle to answer this question, because this is a question for the partners. Where you've got local plans which are out of step with each other, there's the potential for the unmet need to be passed around, like past the parcel at every single examination, and never get dealt with, because either there's no appetite from the authority that's currently examination, or there is no agreed position across the partnership. Now, plenty of examinations have explored that, haven't they? And I'll say it, potential issues with the duty to cooperate in that matter, and not being a duty to agree. But the reason I mentioned Mr. Nelson's comment being very helpful is because it's possible for the partners to arrive at a view when they think they should have an understanding of where they're at with unmet need, so that there can be some form of alignment in local plans, and to prevent unmet need from being passed around each examination, always with potentially a trigger policy, and it never being resolved because it's not pertinent to that examination. And that leads me back to the comment I made earlier about Para 11B, and whether or this is a question clearly for you to answer, Mum, and I'm not going to answer it. But under Para 11B, whether or not it's possible, given the circumstances that we've got, to seal off the trigger policy, examine that now without having any regard to the reasons that it existed, and simply move forwards, or whether actually under Para 11B we have an issue for this, albeit partial review, but a review that will result in a full replacement local plan, as Mr. Nelson mentioned earlier. So I say these things to try and be helpful. I appreciate they're quite difficult things to wrestle, which is one of the reasons why I say helpful for Mr. Nelson, but something for the partners to consider there.
Yeah, I mean, the position that we are in, as far as I understand it, and I'm taking it, is that the substantial review has already commenced. So we're not. I'm not looking for triggers that relate to a review commencing, because they already have. For me, I think the important thing is a submission, when the intended submission is, and I think that whether the statement of common ground is the right trigger or not, it seems to be the general agreement that whatever it's called, it's the only thing that is going to be agreed by the parties, well, assuming that they all agree, but is leading us in the right direction. Mr. Nelson, and I do need to come back to Mr. Thornhill, but Mr. Nelson.
I'm just going to throw something out there, and I'm not wanting to prejudge what you may or may not decide in terms of this review, but is adoption, shall we say, of this partial review by the council another possible? It's something that is obviously within the council's full control. We want to get this partial review adopted for the reasons we've set out about ensuring that we have an up-to-date development plan that we can continue to rely upon. I just wonder whether, I don't know, is that, say, another option as well as a statement of common ground, whichever is the earlier, the sooner, whatever, however we decide it. But I'm just throwing that out for debate more than anything else. Okay,
thank you. I'd need you to give some thought then to how that might look in terms of a modification, just to get a sense of what it might mean for the policy. So we'll come I'm going to ask you to do a list of actions following on from the discussion today, so that I think that would form part of it. Mr. Thornhill, you have kind of raised a few issues about the statement of common ground, what it's likely to take form, what it's likely to take the form of, where you are with the sustainability appraisal. I'm just wondering whether it'd be helpful if you could set that out in a very brief note for me, just so I have something in writing to refer to that could be in front of all the parties. It doesn't have to be long, but just set out the kind of processes that you have in mind, or the group have in mind, the task and finish group. Do you think is that a reasonable request?
Yeah, no, that's fine. Yeah, it's quite it's just a simple what would just be a handful of bullet points, basically the stages where we're at, and then and where we've got to get to. Is that okay? Yeah,
that's fine. Yeah, it doesn't have to be a complicated note, just to set out some of the kind of key matters that you'll be dealing with. I mean, Mr. Lee's referred to, we don't have a date for the wider statement of common ground. That is not correct. As I thought, you in the joint position statement, you have got a date for completion in early 2021. Is that correct?
Yeah, and clearly the key driver here is I think the partners recognise that when you've got a quantified unmet need in a housing market area, and the strengthening of the duty to cooperate that's happened in over the last sort of couple of years with the new NPPF, it's going to be very difficult now, I think, for authorities to get a local plan through, not having dealt with this properly. So I think we're in a slightly different world to the past, where we didn't know what it was. Authorities were able to put a trigger for reviewing and get plans through to adoption. We've now got a figure. And clearly one of the key drivers for this is the Charnwood Local Plan, which is at a very advanced stage. So they're going to need the statement of common ground for their local plan for when they submit, essentially. So that's the driver. Is the circumstances have changed, really.
And the phrase, well, the word in the joint position statement says for completion. North West Leicestershire have referred to agreement, and I think Leicester City Council have also suggested that it should be signed by the parties as well. So I'm just trying to understand what the difference is, if there is any, from your perspective, anyway.
Yeah, I don't know is the answer to that. It's not intended to mean something different. I suppose it's just three words that mean something very similar, isn't it? So in my mind, there's no I suppose there could, of course, be a scenario where the authorities or an authority doesn't agree to it. That wouldn't be unusual in nationally. That's happened in other areas. It could happen here. I'm not suggesting it will do for a moment, but yeah, that is a scenario that could, of course, emerge.
If that was the case, would that prevent the statement of common ground not being signed by anybody, or would it just be that some wouldn't sign?
Well, I mean, I think in that context that the authorities that agreed with it would obviously sign up to it, and those that weren't signed up wouldn't be part of it. If it was one or two authorities, for example, that weren't signed up for any particular reason, then that obviously affects their ability to meet the duty to cooperate through their planning process. So it's complex and it's two-way, but I don't see. I think it would be a big risk for any authority not to sign up to a statement of common ground dealing with this, because when it's their turn to submit a plan or progress their local plan, then they end up with challenging issues around duty to cooperate.
Thank you. I'll come to you in a moment, Mr. Nelson. Mr. De Costa, you wanted to say something.
Yeah, yes, as Mr. Thorne says, it's a little bit complex, but I think our comments were, I guess, clarity and really what's the difference between agreed and signed? What weight does an agreement have compared to a document with it actually signed by all authorities, which, in our opinion, holds more weight than something which is just agreed? And I think the draft policy, we're suggesting the draft policy as it is should contain something which says agreed and signed by all authorities, to hold more weight, really, and particularly as we've got to take this through our politicians as well. I think that's you know, that is something that we've done in the past. I note that I think the November 2019 Northwest Statement of Common Ground was signed by all authorities, agreed and signed by all authorities. So it's just been consistent as well.
Okay, but if it's not signed or not agreed by all authorities, if you're referring to all of the authorities, if it's not, then that doesn't engage the trigger.
Yeah.
So that I think that would be my concern. Mr. Nelson, do you want to say anything?
Yeah, I mean, I'll come back on that point, and I think we've set it out in our response to this question that you set us earlier on in the year. That's partly our concern, is that, you know, what if not every authority signs? I'm not saying this is likely. Well, first of all, I'm not saying that is likely to happen. I've got no reason to think it would. But let's assume one or even more authorities didn't sign. Where would that leave us in terms of plan, particularly if somebody wanted to, shall we say, make mischief? So we decided, no, we were going to carry on the basis of the Statement of Common Ground that was agreed by 6, 7 of the authorities, whatever. Somebody might want to make some mischief to say, well, you shouldn't be doing that because it wasn't signed by all of the authorities. And that was the concern we had. I noticed actually in the Harborough trigger, interestingly enough, that refers to, or that their policy, that actually refers to, I believe, the adoption by the council of an MOU or Statement of Common Ground, which proposes a quantity of housing or employment development to 2031 that is significantly greater than the housing requirement or employment need identified in this local plan. Whether that provides a potential basis, and again, I know we're talking about another modification there, but just on reflecting on looking at that, and again, you've got there is a comfort there that the adoption is by the council, it is in their control.
So you're suggesting the adoption. Could you adopt that? Is that something?
Adopt, approve.
Yeah.
Probably approve might be a more suitable word than adopt, because adopt does tend to have some quite specific legal understanding to it. The other point I was just going to make, and it's going back to what Mr. Thornhill was saying, is, and I'm sure you'll correct me if I'm wrong here, but in terms of process, the task and finish group are charged with leading on the work on the Statement of Common Ground and redistribution. Once we have that agreement at that level, it would be referred up to the strategic planning group and then on to the member advisory group. And thereafter because the member advisory group doesn't have decision-making powers, that was how it's set up, it would then be for each authority to ratify through their own internal processes.
Okay, and that's where the signing would come in.
Yeah, certainly that's what happened with our Statement of Common Ground. The difference was there, a lot of authorities had delegated authority to deal with that. Something like this is most certainly not, I would imagine, for most authorities. I know certainly for us, for example, it will need to go to our full council.
Okay, thank you. Mr. Fox, you wanted to add something?
Yes, thank you, Mum. Just a minor point, but just to add on from Mr. Nelson, I think that very same wording is also set out for Melton, Melton's local plan. It says the adoption by the council of the strategic growth plan and the memorandum of understanding.
Okay, thank you.
That helps.
We'll come on to the strategic growth plan in a minute. Mr. Costa, did you want to say anything else? Your hand's still raised.
Sorry, no, I didn't want to say anything else.
Okay.
No, thank you.
Thank you. Did anybody want to make any further points in relation to the triggers? It seems like we've been through most of the points. Just looking at this list, the only one that has a similar approach as to the current policy S1 is the Odeby and Wigston policy, which refers to, I think it's the policies or relevant policies in the review being out of date. The position that's assuming that that's a partial review. I'm assuming if it's a full review, then all the policies would be out of date, and it would be a similar position that exists here. Are any parties still suggesting that there should be a provision of the plan or policies being deemed out of date if the target for submission is missed? Anybody want to comment on that? So, Mr. Nelson, are you able to fill in that final blank column on that statement of common ground triggers, or at least something that represents the discussion that we've had today? I think it's worth pointing out as well, obviously triggers for the review itself aren't necessarily relevant because the triggers already taken place, but whether there's scope for including in that final column the discussions that we've had in terms of possible changes to the policy. Does that make sense?
Yeah, I mean, I think I probably just need a little bit of guidance as to the specific points that you're thinking of, just so I don't miss them.
Yeah, I think we'd just need to go back through them because a number of points were made. So there was the issue of the statement of common ground covering other unmet need and ensuring consistency in the policy in that respect. So at the moment, your column says no for generic needs, but from what you said, the policy does cover it. It's just that the final paragraph just focuses solely on Leicester.
Yeah, so it's really that final paragraph, I think.
Yeah. The statement of common ground, we now have a date of some sort. So whether that needs to be specifically referred to in the policy or supporting text, because obviously the programme might change. I mean, how set is the programme, Mr. Thornhill? You seem fairly certain that there's an urgency with it in relation to Charnwood. Sorry, you're on mute.
Apologies. Yeah, so the programme for that is set as far as it can be, but obviously with so many parties involved and getting agreement through individual governance processes, there's 9 governance processes to go through. So that's where the uncertainty around, I suppose, precise dates comes from. I suppose there is a scenario though that if the government does publish its standard method in its current form, then there won't be an unmet need in Leicester. So there probably will be a statement of common ground of some sorts, but it won't be dealing with an unmet need potentially. So I think that's why the trigger really needs to refer to the statement of common ground, and a bit like Harbour's trigger policy does, it refers to a statement of common ground identifying an unmet need that leads to a significantly different figure for Harbour or North West Leicestershire. because there could obviously be a scenario where North West Leicestershire don't need to meet any of Leicester's unmet need at all. So again, there wouldn't be a reason for all of a sudden for ripping the plan up, so to speak, and starting again. That they might still be in a position where the plan's up to date. So yeah, sorry, that's probably more questions than answers there. But yeah, in terms of the timetable for the statement of common ground, that's fairly strongly embedded, because of the imperatives of imminent local plan submissions, basically.
Yeah, I mean that's an important point about whether North West Leicestershire is having to meet the needs. Just looking back to the to whether that could be included in the reference to generic unmet needs as well. Should that be the case?
I think referring to, I think where we've got an unmet need in the housing market area, and where that leads to North West Leicestershire's housing figure changing significantly above what it's got in its plan to 2031, then clearly a review of the plan will be needed. If North West Leicestershire isn't picking up any of Leicester's unmet need, I'm not saying that will be the case, but it is something that could happen. Or if Leicester's unmet need disappears because of the changes to the standard method, then again, why would North West Leicestershire's plan become out of date and need an immediate review?
Okay, thank you.
Unless obviously their own housing need increases significantly, in which case they'd have a cliff edge in November 2022 anyway, because the 5-year supply cliff edge would kick in at that point, and the local housing need and their policies would be deemed out of date, unless they were miraculously able to find a significant number of homes in that period.
Okay, thank you. Mr. Fox, you wanted to say something?
Yes, thank you. I just wanted to add one more point. I think it's probably something we haven't really touched on, but we've obviously been focused quite a lot on housing and the generic sort of housing unmet needs across the HMA. But I think it's important we don't lose sight of the strategic B8 needs, which is going to be an important element of the substantive review. And I know that the previous plan, there was a strategic distribution study which identified a need across the whole of the FEMA, which is similar to the HMA. And there's another study has been updated, and I think it's close to being completed. But I think it's just important that policy S1, in terms of the sort of generic needs, it's important it doesn't just focus on housing. It needs to be cognizant of sort of strategic, especially logistics requirements.
Yeah, we'll discuss that to some extent tomorrow as well. But yeah, just looking at the joint position statement, obviously that does identify an employment land need as well. So the policy would need to cover that if it's identified, obviously, that North West Leicestershire is somewhere that need is met. Mr. Nelson.
Yeah, I mean, it's just to say that in terms of certainly the unmet need from Leicester City on employment, at the time that the draft policy was being prepared and indeed submitted, we weren't aware of an unmet need. We weren't notified by that until I think it was March time. But yes, certainly any issue of unmet need would be housing or employment.
Okay. And does the policy specifically say that, or would that need an additional change?
Just talk about unmet needs, and within the housing market area. Okay, it's housing market area, which is the same thing as the FEMA, but No, it just talks about unmet needs, so I'm not sure it does need to necessarily say anything else.
Is it worth referring to the FEMA as well, just to be certain?
Yeah, perhaps say HMA/FEMA.
Okay. So that was another alteration potentially, and you also referred Mr. Nelson to the adoption of the partial review of it as another trigger. I think if you could draw up some wording in relation to that.
Yeah.
I think that's all I've got. And then there was a note from Mr. Thornhill.
We perhaps just worth saying now, we were looking at the policy earlier on, just in discussion internally, and within the policy as it's currently proposed, just before the insertion of the bit about the statement of common ground, where it talks about the result of inability of one or more authority to accommodate its own needs as identified in the Leicester and Leicestershire Housing Economic Development Needs Assessment. Actually think it probably useful to just take that out. And I think that picks up to some extent on the point that the Leicester City, because actually the unmet needs might not be to do with the head note, it might be to do with the standard method, it might be to do with another piece of evidence that nobody's aware of at the moment.
Yeah, I think that would be sensible.
Yeah.
On that basis. I did want to come back to question 6B and the timetables, the timing. So if the statement of common ground was agreed early in 2021, how does that affect your replacement local plan being in place by November 2022?
Yeah, it depends exactly what you mean by in place, I suppose. But if we're talking of submission, I suspect there's not a huge difference. Being realistic, we're talking early 21, so February, sort of March time, 18 months, take you through to August, September 22, and November 22 in terms of the local plan of being 5 years old. So it's not a huge difference, but virtually the same.
Okay, so no big impact there.
Yeah, and just thinking about if you were to go with adoption of this partial review, whilst I haven't looked at it in any great detail, I do know, for example, that we have a council in February of next year. That may just be possible. So again, we're on sort of similar time frames. Okay.
Does anybody else have any points to make in terms of the triggers, the timescales, dealing with question 6 to 6C that we haven't covered at all, or you just want to make an additional point? I just want to be certain that everybody's had their say, and that we've not missed any points that you made. No. Is everybody happy just to continue on to question 7? We have been going for an hour and a half, but is everybody happy just to carry on for a few moments? Yeah, okay. I'll just seen Miss Green have a sip of water. It's quite warm this afternoon, so does anybody need a comfort break or to cool down? No. Okay, so question 7 relates to other emerging plans or plans such as the strategic growth plan, which have the potential to impact on the statement of common ground or the substantive review. Might be helpful to understand a little bit more about the strategic growth plan. I think a couple of participants or representatives have suggested that the policy should refer specifically to the growth plan. but it'd be helpful to understand a little bit more about its status, where it sits in terms of the planning framework for the area. Mr. Nelson, would you be the person to answer that, or would that be Mr. Thornhill?
I can certainly start on that. So the strategic growth plan is already in place. It was approved by the various local authorities. I'm hoping this is where Mr. Thornhill might come and he might have the more exact date, but it is in place. It has been agreed. It is an informal plan. It's not a statutory plan, although we did try to mimic as much as possible the process for doing a statutory plan. But for example, it wasn't subject to examination, but it was subject to a sustainability appraisal. And its intention was to, first of all, set out a long-term vision strategy up to 2050 and set out some quite ambitious growth targets. And it was to provide a framework for local plan preparation. So, for example, in terms of the substantive review, which we're currently engaged in, we're already looking to sort of a 2039 sort of end date. And we're looking at how we can take on board the strategy in the strategic growth plan. So, and you'll have seen it made reference to a number of representations about the Leicestershire International Gateway, which is is certainly not a defined area, but it covers the northern part of northwest Leicestershire and Charnwood, and up to 2050, it identifies that there is potential to accommodate about 11,000 new homes in that area. So, for example, the work we're doing on the substantive review is looking at a number of strategic developments that have been put forward to us through our SHELAR process in the northern part of the district. And I think I referred earlier on today to the fact we've had an infrastructure study done to look at what that might mean. So that's how the strategic growth plan would be sort of taken into account in as part of the substantive review. So just to then say, so again, a lot of the discussion has been about triggers, but the growth plan is already in place.
Okay. So it's already in place and it's informing the work that you're doing for the substantive review. Did anybody want to make any points about the strategic growth plan? I know a number of you have done. If anybody wants to say, yes, Mrs. French.
Thank you, Madam. I'd just like to say really that I feel the strategic growth plan is quite important, although it doesn't have the statutory status. I think it's quite important for identifying infrastructural needs in the longer term, and I think it's evolved from where it started, but it is important to make sure that development doesn't preclude future development in strategic areas.
Okay, thanks. And would it be your suggestion to include a reference to it then in within the policy or supporting text?
I think it would be helpful, given that it doesn't have any formal status, but I don't think it's the end of the world if it's not there. Okay,
all right, thank you. If you were to suggest somewhere for it, where would that go? Have you had any thoughts about where you think the reference should be? Should it be within the policy itself or supporting text by way of background?
I would say supporting text, but I haven't specifically thought about that.
Okay, thank you.
Thank you.
Thank you. Mr. Pendle.
Thank you, Ma'am. I don't know about other people's screens. On my screen, Mr. Thornhill has frozen, and he may or may not be there, of course. The comment the comment about the growth plan already being done. Mr. Thornhill has, told us that there's a never-ending task here, and clearly there will be other iterations of the growth plan. The current growth plan, of course, deals with Hedner, and we've had a conversation. Mr. Nelson suggested that wording associated with the Hedna is taken out of the policy because it's part of a past regime, and of course we're now standard method and an emerging standard method. That leads me to think that the strategic growth plan that is adopted has, you know, it has a certain shelf life. I agree with Ms. French. It's very good at painting a picture of the future and what that future may look like in terms of strategic growth and strategic infrastructure required to deliver that growth. How you fit your housing and employment pieces together around that strategy is a different question. So whilst the strategic growth plan has been done, you know, clearly it has been done, and Mr. Nelson's not incorrect in saying that, there will be another version. And Mr. Thornhill's back now, so perhaps you know, through you, Ma'am, we could just hear a little bit about that, because my sense is, you know, when I talk about being less concerned with the names of documents and more concerned with the ingredients that we use for plan making, I think it's important to know what the strategic growth plan might do next. And I appreciate Mr. Thornhill can't say, well, it'll be X thousand here and X thousand there. I don't mean that. I mean, what, you know, will there be another one? Are we done? I don't think we are, and I would expect him to say, no, we're not. There will be another version, in which case it might be important to understand what relationship that might have with the policy. So with Hedna coming out, question mark over what it's replaced by, and to answer your question of Ms. French, my sense is that the appropriate place for that would be in the reason justification in the supporting text, for that to be explained, for the rationale for that to be explained. But for the thing that we are trying to deal with, which is unmet need that's sloshing around the gunnels of the ship, for unmet need to be referenced probably in the policy. But I'll hold my counsel on the rest of that, Ma'am, if I might. But I just wanted to hear perhaps that future of the strategic growth plan, given the certainly a sense I picked up that perhaps that's done, but I wouldn't necessarily expect it to be so.
Yeah, I mean, I will come to Mr. Thornhill. I noticed the joint position statement is kind of marketed under the banner of the strategic growth plan. So, is it something that is going to continue, and will there be updates to that?
Yes, I suppose the way I view the strategic growth plan is it's a long-term vision to 2050, and quite an ambitious one. I think in terms of this local plan, the growth plan really looks post 2031, so it looks at that time post 2031 to 2050. So in terms of the plan that we're dealing with here, the growth plan doesn't really bite on that plan. The idea is that we can't continue doing what we've been doing in the past. We need a more strategic long-term approach, and so there'll be the substantive review, which obviously goes to 2039, will be influenced to an extent by the growth plan. So what we've got is a vision, a really long-term one out to 2050, and then what the intention is to use the duty to cooperate and joint working to ensure that remains relevant to local plans which consider shorter timescales. So the first step is dealing with Leicester's unmet need that it has now. So we're looking to do the statement of common ground to 2036 to deal with Leicester's unmet need. The sustainability appraisal that we're doing will inform that, but obviously the strategic growth plan, which is where we want to end up at in 2050 in some respects, will be a factor that's considered within that. Not the only factor. There are obviously others, because we're dealing with a shorter timescale in much more detail than the growth plan did. Then obviously as time goes on, the duty to cooperate remains, and it's a constantly ongoing process. So we'll be looking to update the evidence strategically and jointly as we go through the process, and that will layer up over time, leading in some respect either to the delivery of the growth plan, or if the evidence as agendas change over time leads to a slightly different outcome, then we'll obviously have to respond to that and potentially review the growth plan. So So yeah, so it's there. It's a vision that sits there in the background as that the authorities have agreed where they'd like to get to. But we need to make sure that stays relevant and up to date by constantly updating the evidence through the duty to cooperate, so that it's relevant to local plans at whatever time they submit. Obviously, we're dealing with Northwest here. Charnwood are coming up soon, and in 2 or 3 years' time, there'll be other plans going that deal with longer timescales.
Yeah, and then just on Charnwood, have they had regard to the strategic growth plan at this stage? Is it something that's been relevant to their plan considerations?
Yes, it's in there. It's mentioned quite a lot actually in their local plan. So it is in there.
So there's a kind of forerunner for how it shows how that influences the more local plans, as you said. That's what its intention was. Thank you. Did anybody want to add anything in relation to the strategic growth plan, or refer to any other plans or other things that might affect the replacement local plan or the partial review? No. Okay. Anybody got any final comments to make for the day? Mr. Nelson.
Yeah, I just wanted to, I suppose, 2 things. First of all, the discussion that we just had with Mrs. French about reference to the strategic growth plan and in the supporting text, is that something you want us to look at trying to weave in to changes to the text to support policy S1?
I think it would help. It would certainly help set some context, I think, but not only that, but also referring to matters like the standard methodology, because you're taking out that reference to the Hedner. But I think maybe part of the not replacement in the policy, but a further kind of explanation of all those things that might influence or will influence future needs. So it would certainly be helpful to include it in that.
Okay, I mean we've already started that process, so that's fine. And I suppose then that follows on from that is in terms of any thoughts you have about the process for doing this. Yes, we can draft something. Do you want us to share it with the participants? Do you want us to just send it to you in the first instance?
I think what I'd like to see first is that we get an agreed set of actions. So we've referred to a number of points. I think with that, I don't want to see the detailed wording of main modifications, but a summary of what it's likely to contain, because I think we've referred to quite a few things today. So we'll agree that list between us, and once that list is agreed, then there will be a process of agreeing modifications that will then be produced for formal consultation through the main modifications process.
Okay, that's fine, thank you.
That list of actions would be a document that we would publish on the website, so everybody can see the outcome of the discussions. Does anybody else have any comments to make? Again, on anything we've discussed, just as a final point. No, I'd like to thank you all again for taking part. It's been slightly warmer this afternoon in here. So, yeah, thanks. I meant to say to you, for those that you're wearing your jackets, please you don't have to.
No, she says.
Sorry, I forgot right at the start. I was going to say, please don't be so formal. It's unless you're
Problem is not used to it.
Yeah.
The problem is I'm not used to after 6 months of wearing a t-shirt. It felt really uncomfortable yesterday.
You're now going to start a hair running as to what we're wearing tomorrow morning.
Well, I think it's going to be another warm day, so as long as I don't mind if you're not, for the gentlemen, if you're not wearing jackets, that's okay. If your house is like mine, it's not air conditioned, then I don't see why you need to sit in warm jackets for the day. I'd like to thank everybody for taking part today. I hope you've found it okay in terms of the process. And yes, thank you, and to Carmel as well for inviting you all to the sessions, and for keeping quiet as well. I haven't heard a peep from anybody whilst I've logged on, so thank you very much. And I'll say goodbye. I'll see some of you tomorrow, but for those that aren't coming along tomorrow, thank you for your participation.
Thank you.
Okay, thank you. I shall leave now. Thank you. Bye.
Bye.
Bye.